Okay. So, welcome everyone. It's great to have everybody here today. I think it's very sunny today at the moment, and I know a lot of people don't want to be in their houses. A lot of people want to be outside. So I think it's worth the wait and having Samuel and Susannah here today. But of course, most of you know me. My name is Christian Harrison, and I am. Okay. So my name is Christian Harrison. I am privileged to be facilitating the research seminar series of the School of Business and Creative Industries, and of course, UWS as well. I think recently we won the best higher education institution based on Herald. So that's a good one for the university as well. But of course, we all know the rules of Zoom. Let's try to mute ourselves while we're not talking, and that is quite important as well. And I can see people's faces, so feel free to put your camera on if you want to, so you don't need to be in the digital shadow. And if you don't want to, of course, you feel free. I can see Iene here, just came in, no pressure. But that's good. It's good to have everybody here today. One of the things I always tell people, try to introduce yourself. People have seen it already on the charts. You can say hi. Well, I can see John. John has been a fervent person here as well. So trying to tell us where you're coming from. One of our traditions over time has been trying to tell people to introduce themselves in their native language if you can. So we've had people using Mandarin, using Gaelic, using different things. So you can do all that if you want. But it's great. But yeah, we have had this research seminar series over time, and we have had fantastic presentations, people expressing their research. And today we're going to be having something so fantastic and something so apt. And we have been waiting for this day over time. And we'll be looking at children's rights, litigating children's rights, especially from the United Nations Convention of the Rights of the Child. Of course, children are very important to us, the rights of the child. We want to know how, if it has been approved or approved by the UN, how can we ensure within Scotland and within the UK, how can it be applied within our domestic setting? And we have two experts in the field that will be telling us so much about this. So no pressure, Samuel and Susannah, we have been waiting for today, and they'll be telling us so much about this at the moment. I think from John, okay, John is introducing himself and is telling us where he's coming from as well. So there's no pressure about it, but clearly they will tell us so much about the litigating children's rights. And after that, we would have questions and of course, questions and answers as well. So the first thing I'll be doing is I will be introducing them. So, okay, we can see Anita. So I'll be introducing them, and the first person is Samuel. So Samuel White is a lecturer in the School in Law, in the School of Business and Creative Industries, and works for UWS. He completed his LLB at the University of Dundee before working in risk and compliance in the financial service sector. And in 2017, he returned to academia to complete a PhD in the University of Dundee, funded by the Carnegie Trust for the Universities of Scotland. And Samuel's doctoral research is investigated in the impact of incorporation of human rights treaties in UK domestic law, examining changes brought about by the Human Rights 1998 human rights protection in the UK. He has presented his research at conferences around the world, and evidence based on this research was recently cited by the UK Parliament's Joint Committee. So well done, Samuel. And Samuel's research interest includes interaction between UK constitutional law and the protection of human rights. So you have a scholar within this space. And one of the things that Samuel has not, like this is a summary of their CV, but they are also experts in the field. They have gotten research grants from very big funding bodies, and also one of the successful studentships as well. So they're doing a lot of good work. So well done. And we'll be having Samuel that'll be telling us so much about this. And of course, we also have Susannah, who is also a lecturer in law at the School of Business and Creative Industries at the University of West of Scotland. She's also a lawyer, well, rather coming from University of Dundee. She's from the University of Glasgow, and she has an LLB. She received a 1+3 scholarship. Like, they're very good at receiving scholarships, both of them, from the Arts and Humanities and Research Council project. And she was looking at researching multilinguality at borders. Has received training in qualitative research during her MRes there as well. Her PhD examines advisoryalism, sorry for speaking about that, I tend to struggle with that, isn't it? In the Immigration and Asylum Tribunal, and employs observational and interview data to consider how hearings are conducted in reality. So Susannah is interested in using socio-legal methodologies as well. And similar to Samuel, she's of course gotten grants within very good funding bodies, and also they are very successful in getting PhD studentships as well. So this is the summary of the kind of people that we have, the experts that we have today, and I would give them the opportunity to start the presentation. And it's great to have both of them here, and they'll be telling us so much about litigating children's rights. So the floor is yours, Samuel and Susannah.
Thank you very much, Christian. I presume I make the bank transfer for such a generous introduction shortly after we've done this talk. Hopefully, we'll be able to live up to that very kind introduction. Thank you very much, Christian. And I'll just share my screen now, and hopefully everybody will be able to see that in a second. Can everybody see that presentation? Perfect, I'll just get it to start. So as Christian says, today we're talking a little bit about litigating children's rights. And in doing so, I wanted to start by just talking a little bit about the wider context, and it touches a little bit on some of the funding that Christian just mentioned. The basis of this presentation really is as part of a slightly wider project that Susannah and I are involved with, that's been funded by way of an RSE small grant. Recently, we started the project in May, just gone. So we're fairly early on in the progress of this project. And the project itself examines the way in which courts use treaties in their decision making. Particularly at the moment, we're looking at Scottish courts, but there are lessons for the wider UK, and there's plans to expand this research. And in looking at these courts' decisions, we're seeking to explain, to analyse, and to encourage the use of these treaties within the Scottish courts, with the view of protecting human rights and encouraging the better protection, stronger protection of human rights within the UK more generally. Given the newspaper stories, I don't know if anybody's seen the headlines this morning, the European Court of Human Rights is not particularly popular with elements of the press following a decision to halt deportation to Rwanda yesterday. So it's probably more important than ever that we discuss and fully understand these aspects of human rights. At the peril of ensuring that we don't have a sort of Trades Descriptions Act claim for what we will and will not do in today's presentation, I just wanted to cover a little bit about what we are actually going to say and what we maybe won't have time to touch on. Starting with the things that we won't have time to discuss with you, we don't really have time to discuss this kind of substantive content of the United Nations Convention on the Rights of the Child, the UNCRC. That's sort of beyond the scope of what this project really looks at. And I've got a copy of it next to me, some 45 articles that could take up an entire presentation on their own. So we'll talk more about how we see this project insisting in the protection of human rights, and particularly children's rights, but we won't necessarily have time to discuss the substantive content of the treaty. Similarly, we don't really have time to touch in any great depth on the proposed incorporation of the UNCRC into Scottish domestic law. Those of you who've been following the issue will know that the Scottish Parliament a couple of years ago voted unanimously to incorporate the UNCRC into Scots law. That bill was successfully challenged by the Supreme Court. So at the moment, we're not quite sure how that's going to look, and any commentary from us on that is going to be purely speculative, and perhaps Christian will have us back when we know a little bit more about that and we can actually say something that's useful. The other thing we simply can't do today is provide final results and outcomes to the project. We're not that far along. We have a good idea of what they may well look like, but we can't talk about it. So that's what we can't do. What can we do? Well, we will talk to you about the project that's underway, how we're going to do this, and what we've seen so far. We're going to also to explain why this work is necessary, what we add to the existing field of knowledge with this work, and why this work will hopefully improve human rights protection in Scotland, and the way in which we're going to go about doing that. The structure for today's talk is fairly simple. We're framing it around 4 key questions. What are we doing? Why are we doing it? How are we doing it? And where's that going to take us next? So starting with the first of those questions, what are we doing? This is to provide you with a kind of overview of the project, really what we're asking, how we're seeking to understand it, but also to give you a little bit of background on what we've discovered so far. So this project really asks one key question, and that's how have courts used human rights treaties in their judgments over the last 2 decades? So how have Scottish courts in the last 20 years engaged with these treaties, applied, not applied, differentiated these treaties, and why? And by asking this question, we're looking to understand 2 things. Firstly, we want to understand why lawyers use these treaties in their submissions before courts. That's the starting point for any judgment using these treaties, is lawyers need to frame their arguments around the UNCRC, around the International Covenant on Civil and Political Rights. Without that, the courts can't respond to those arguments. So first we need to understand why lawyers do this, and then we need to understand how lawyers respond when the arguments are framed around these instruments. And Susannah is going to talk to you in a little bit of time about how that works and how we plan to measure and assess that. That sort of leads us on, if we're talking about a broader project, to the very legitimate question, why is it children's rights that we framed today's presentation around? So there's a very, I think, very strong answer to that, and that's that despite the fact that this project is broader than just the UNCRC, the initial evidence suggests that the UNCRC is far and away the most widely used of these treaties. It's the one with which the Scottish courts engage in most depth and most frequently. And also Scotland, because it's planned to incorporate the UNCRC into domestic law, and I've highlighted incorporate because it's an important word that we're going to come back to in a bit. Because Scotland's already tried to do this, there is this kind of move to understand how we can better protect children's rights, particularly through legislation. And when that comes in, we can start to map the changes that incorporation brings against what came before, and we can see whether that does bring the progress that's intended to happen. So there's 2 facets here. 1, we're looking at the treaty that's most widely used, and 2, we're setting up, hopefully, to look at how incorporation changes things if that happens later on. And when I say the UNCRC is used more widely than other treaties, it's quite a significant gap. There's 6 treaties that we're looking at. There's all sorts of acronyms under there. We can work through those in order. First of the treaties is ICERD, the International Convention on the Elimination of All Forms of Racial Discrimination. The Scottish courts don't appear to have engaged at all with that in their decision making. Similarly, the ICESCR, the International Covenant on Economic, Social and Cultural Rights, hasn't been the subject of much decision making. Only 4 judgments in the 20-year period have engaged with it. The sister treaty for the International Covenant on Economic, Social and Cultural Rights is the ICCPR, which was the subject of my PhD, amongst other things. And it's this International Covenant on Civil and Political Rights, and it looks at very similar rights to the European Convention itself. That's fared a little bit better. The courts have engaged with it on 17 occasions, but still that averages out at less than once a year. And the position for CEDAW, the Convention on the Elimination of Discrimination Against Women, and UNCAT, the United Nations Convention Against Torture, fewer than 10 between them. On the end, then, you see that the courts are engaging with the UNCRC far more regularly. 83 occasions in 20 years, they've used it in their judgments. Of those, some are positive, some are neutral, and a few are negative. But generally speaking, the courts are engaging relatively well with the treaty and applying it in their decision making to arrive at more child rights centric conclusions. And we'll come on to the way in which they do that shortly. But that really hopefully gives you a flavor of the what we're doing. We're looking at these treaties in these judgments. We're trying to understand how the courts are doing this, and that should lead us on to understanding better how we can improve that use and encourage that use. That takes us hopefully then to the second question. That's what we're doing, but what's the purpose? Why are we doing this? And really, this is framed around the need for better human rights knowledge to ensure better human rights protection. If we understand what works, if we understand what lawyers can do to frame their arguments successfully around children's rights, we can encourage them to do it more frequently, we can encourage them to do it more successfully, and we can really incorporate that thinking into those arguments that are made by lawyers with a view to improving human rights protection for children and in other contexts for all persons. The why also involves a quick international law digression. So apologies to those of you who've done international law before. This will be a quick refresher. For those of you who are new to it, hopefully this makes a little bit more sense of how and why we're asking this question. There are two approaches to the way international law is treated in domestic legal systems: the monist approach and the dualist approach. A monist approach says that international and domestic law, national and international law, form one single legal order. This is the words of former Judge James Crawford at the International Court of Justice. So according to monists, it's all part of one system. National law, international law should be coherent and consistent. They should look the same and reflect one another. The dualist approach, on the other hand, treats international law and domestic law as separate. It says they are two completely different things. And in order for international law to be mirrored in domestic law, some form of act is required at the state level. Normally that's legislation, and that brings the treaty law into the domestic legal setting. In human rights examples, you can see that from the European Convention on Human Rights being brought into the UK domestic sphere by the Human Rights Act. The Human Rights Act is what allows me to go to court in the UK and say, my rights have been breached and I want to raise an action on that basis. The reason that we need to understand the monist-dualist divide is because the UK is a very strongly dualist system. That's the words again of James Crawford. And that means that we take dualism very, very seriously. For any form of international law, with the exception of European Union law, which we will leave to one side for today, to take effect, something needs to happen at the domestic level. Really, that means Parliament has to make legislation that gives international treaties effect in the domestic setting. So we talked about the example of the European Convention. And that means that where no incorporation takes place, while we don't move the international law into the domestic setting, there is a gap between international protections for human rights and domestic protections for human rights. Take the International Covenant on Civil and Political Rights, for example. The UK is bound at an international level to abide by that treaty, but I can't go to Paisley Sheriff Court and say, my rights under that treaty have been breached and I would like to do something about it. The same is true of the UNCRC. It isn't all part of domestic law, which means I can't go and say my Article 7 right to birth registration, name, nationality, and care under the UNCRC has been breached. I want to do something about it. So with no incorporation, no right of action exists. Without incorporation, my rights aren't fully protected at the domestic level. That doesn't mean, however, that courts can't try to do something about it. And this is why we're looking at these decisions, because courts are empowered to use these treaties that haven't been brought to the domestic level in limited circumstances. We can look to the case of the Crown against Lyons and Lord Bingham's judgment to see an example of this. So in Lyons, Lord Bingham said that we can use unincorporated treaties. So that's those treaties that are part of international law but aren't part of our domestic law. Courts can look to those when they're interpreting statutory ambiguity. So if you've got a piece of legislation and it's confusing, it's not clear, and you have two possible interpretations, the courts can look to the treaty to see how they might frame that interpretation. So if they've got two interpretations, one of which protects child's rights, one of which doesn't, then you can argue that they ought to protect children's rights when they're doing so. Courts can also use treaties to help them work out how they should exercise discretion. If the court has freedom to act in any way, then you could hope that they would do so in line with international obligations. If you say, my treaty rights will be breached if you act in a certain way, you can probably persuade the court to exercise their discretion in a rights compliant manner. Finally, courts can use these treaties, these unincorporated treaties, when they're developing the common law. Common law is the group of cases and rules that courts have developed themselves, and they can develop it further with their own decisions. And when they're looking to develop their common law, once again, they can look to treaties to help guide them in their thinking. But the problem for all of this is that before courts are likely to do this, lawyers need to frame their arguments around this. A lawyer needs to say, you are exercising discretion, but you should take into account the UNCRC. You're developing the common law, but look at the right to adoption in Article 21 of the UNCRC. Have you thought about this? So lawyers need to understand and be willing to apply these arguments before courts can respond to them. And that's where this project hopefully comes in. We're going to look at where courts respond and teach lawyers how they ought to frame these arguments to make these arguments more effective. So that really takes us to the next slide. So why are we doing this? We want lawyers to understand when and why they can use the UNCRC. And to do so, we need to understand what they know and where they currently do so. Beyond that, we need to understand how courts respond. It's all very well telling lawyers that they should make these arguments, but if we know that every single time they do so, the court says, that's irrelevant, I'm not listening to your argument, there's no purpose to it. So we need to look at how courts respond. Do courts like certain structures of argument, certain styles of argument? If so, we need to encourage lawyers to adopt those. And by looking at how lawyers use it and how courts use the UNCRC, we aim to train lawyers to make these arguments as effectively as possible. The aim of that, therefore, is to encourage lawyers to use the UNCRC in their litigation, to litigate children's rights more frequently and more effectively, to ensure that litigators are doing this and ensuring that the UNCRC can be applied as often as possible, and in doing so to secure better rights protection for children's rights across the UK as often as possible. That's the what and the why, and that brings us to the how. So you will be pleased to know that I'm winding up. You have one more slide for me, and then I'll hand over to Susannah, and you'll get some variation from my voice. But briefly, the first aspect of this is a quantitative analysis of courts' decisions. That's what's currently underway. You've seen a little bit of it already in the earlier slide. We're doing this for a number of reasons. We're asking how is the use distributed? Are courts using it more frequently, less frequently? Are there clusters in certain periods? So where we discuss incorporation more, does it appear more frequently, for example? We also want to know if certain courts are more positive. If we find out that Paisley Sheriff Court absolutely loves a UNCRC-based argument, we can encourage lawyers to use them there. Similarly, if we discover that it's always the appeals courts, the Court of Session, using these, we can suggest to lawyers that they save those arguments until they're on appeal. We also want to see if there's any trends. Is it becoming more frequent, the reference? Is it becoming more successful? And in finding all these answers to all these questions, it will allow us to assess these developments, to see these changes and patterns, and really to target the work that comes next. The qualitative research that comes after can really be targeted effectively by use of these quantitative analyses. And these kind of comparing patterns and targeting qualitative research means that we can manage to do this most effectively. That's my aspect of the presentation done. I'll now hand over to Susannah, who's going to talk to you about the qualitative side of this.
Thanks, Samuel. So in terms of our sort of qualitative data, what we're looking to do is to, first of all, kind of understand how and why legal practitioners either use or do not use unincorporated rights instruments in their arguments in court. So we know that courts can rely on these treaties, but that this in part relies on the lawyers framing their arguments around these treaties. So that's basically our reasoning for speaking to the lawyers themselves. So the questions that we want to answer are essentially who uses or does not use the unincorporated human rights treaties, such as the UNCRC. Why do those who use the treaties in advancing their arguments use them? How are these arguments received by the courts when they do use them? And who does not use unincorporated rights treaties, and why not? I'll get you to go to the next slide, Samuel. So we plan to speak to legal practitioners directly, and to collect this data, we plan to use initial surveys first of all, and then semi-structured interviews. For the interviews, we're hoping to get a sample size of around 10 to 15 legal professionals. Next slide, please. So our surveys will provide a kind of scoping exercise really to develop an understanding of the reported usage of unincorporated rights treaties by, for instance, the UNCRC by legal professionals. And it's through the interviews that we're really going to try and flesh out our understanding. So we've actually needed to take quite a bit of time to try to consider and develop our questions for lawyers, and we're still in the process of refining them at this stage. We've had a bit of a dilemma in coming up with these questions. So while finding out about why lawyers use treaties such as the UNCRC is fairly straightforward, we're asking people to explain why they do something. Finding out about why people don't do something is much more difficult. So it might be quite a difficult question for participants to answer. People don't usually think too much about things that they don't do. Additionally, if their reasoning is due to there being a knowledge gap or a lack of awareness about the possibility of using them, face-saving responses might kind of skew our findings about the underlying reasons. So we want to build a picture of the usage of these unincorporated treaties, but to build this, we're going to need to furnish a kind of bigger picture and get a more holistic understanding of professional practices of lawyers to examine where the use of these treaties, such as the UNCRC, fits or doesn't fit. Next slide, please. So in painting this picture, we're looking to capture a detailed understanding of the kind of taken for granted habits of legal professionals. And in doing so, we're trying to achieve two things really. Firstly, to get the understanding, which is going to feed into providing education in the form of continued professional development training. And I'll return to this in a moment. But we're also going to be feeding into a kind of broader understanding of the way that lawyers use the law or don't use the law. And in doing so, we're going to be feeding into a kind of body of literature called legal consciousness. So legal consciousness can mean different things. It can mean many things. And in the past, it has been used to consider how ordinary citizens interact with the law, how they experience the law, and how their perceptions of the law come together to form this sort of taken for granted understanding and taken for granted habits. More recently, it's also been expanded to consider how the kind of internal processes of law work. So in this project, we're looking to find out about how lawyers use the law and formulate their arguments. Next slide. We're going to be on this one really quickly. So what comes of this research? And on to the next. So we plan to publish our findings of our quantitative analysis of courts' decisions and the findings of our empirical research. So we're going to publish them as open access publications. In doing this, we're hoping to contribute to the academic understandings of the use of human rights treaties and broader literature, which is looking again at how lawyers use the law. We're seeking to also help encourage the use of treaties such as the UNCRC in courts. And as Samuel said, this is with an aim of securing better rights protection. So it makes sense for us to target resources at those who are going to benefit from them. In our case, a natural target is the legal professionals themselves. So an important part of the project is developing CPD training for legal professionals. So we're seeking to learn from those who've used treaties effectively and pass this knowledge on to other legal professionals who want to incorporate this into their practice. A key element of it is going to be utilising kind of peer-to-peer learning. So what can the lawyers who want to learn about using treaties learn from those who already do so? And in developing the CPD, we're going to draw on the experience of our participants and incorporate their kind of direct involvement in both the development of and the delivery of the CPD. Overall, we're hoping that this project will serve as a kind of small step towards better children's rights protection in Scotland. Thank you very much. I will let Christian, I'll hand back over to you, Christian, for questions and answers.
Okay, thanks very much, Susannah and Samuel, for the very insightful presentation. It was great. I like the fact that you can see what's happening, your research, how your research is going to inform, hopefully, the practice within Scotland. So thanks so much for that educative and informative presentation. So it's now left for us to ask questions, comments, questions for Susannah and Samuel, anything you want to ask them, or any feedback or any comments you want to provide. So this is the time for you to ask them questions about their study or comments or anything you want to say. So questions for them?
I guess also thoughts are welcome, or if
and thoughts.
Someone else research.
Okay, I think let's start with John. John is saying on the chat, why wouldn't you start with the specific judges that have seen these treaties, used in their courts? So that's John from the States.
Yeah, and I think, is it okay if I come in, Samuel?
Absolutely. I was about to land you in it anyway.
So I guess you're probably referring to kind of speaking to lawyers rather than speaking to judges. So this is something we hope to be able to move on to. We hope to be able to move on to be able to speak to judges. One thing that is difficult in terms of conducting legal research is getting access. And getting access to judges is quite notoriously difficult. Judges are not all that keen to speak to researchers, or if they do, they're maybe not able to be all that kind of upfront and frank with their responses. So it'll involve a number of steps in order to get permission to speak to judges. So we do hope to, but that will be something we build up to.
I think there's also to add to that, there's a real danger that judges are very reticent to engage on any topic they're not quite well versed in. I think they're often very worried about appearing anything other than expert on matters of law. And on an issue like this, where it is so down to the arguments that lawyers are making and to which they respond, there's a risk that they will kind of stonewall or tell us what we want to hear. And I think other projects that I've been tangentially involved with have taken sort of 18 months to get access to the judges. And I don't particularly fancy a call with the RSE asking them to extend our funding because we haven't been able to speak to anybody. So it's an excellent question, as Susannah says, John, and I think hopefully we can springboard to that and at least go with some data and maybe fine-tune the questions that we want to put to the judges before we get the opportunity to speak to them. But no, that's an excellent question.
Okay, thanks, John, for that. So any other questions, or John, are you happy with it, or do you want them to elaborate more? Either way, any questions for?
I guess also just about the. Oh, sorry, was John coming in?
Yes, I'm happy with the answer you gave me. There's a lot I don't know about this topic, but yeah, the other side is why not go the opposite way? Why don't you go to law students and see what they say about the topic, and they might have a perspective that's unique and different, but by bringing it up at that time, they might pay more attention to it through their education.
That's another excellent point, and I think we were discussing this the other day. Actually, what we seem to be seeing so far is one of the reasons that lawyers don't use these treaties is that many of them who are at the stage where they're making these arguments before appeals courts studied law long before international human rights law was a required subject. So they just don't necessarily have the education. And I think that's a very strong point, is making sure that we start the education and start the awareness early on. And hopefully we can start inculcating that in our teaching. I'm looking at Carolyn now because she's going to have to be the one who allows us to do that. But I know we already teach international human rights law, and actually tying this sort of work into that and adding research into teaching is very much something I think we're planning to do as a law unit. So that's another really good point. Thank you, John. I don't know if Susannah wants to add to that.
Yeah, no, I mean, I think it also just feeds into kind of our wider kind of projects in the law unit as well, and just looking at how we can get kind of law teaching and expand that really, and even expand that beyond our law students and think about how we can kind of incorporate legal teaching in schools potentially, because I think it's not only law students that can benefit with knowing about the law and about human rights, it's really all of us. So it's something we're looking at doing is to look at possibilities for increasing kind of general education in human rights.
Okay, thanks Susannah and Samuel for that, and thanks John. I think before we go, I think we have a hand raised up, but before we go to that in the chat, I think Zanida is saying, I'm based in the UK, but the idea of a full cooperation between the courts and treaties to ensure decisions are always made considering the best interest of the children is a great idea. And I appreciate your work and effort to put that plan into practice and hopefully have systems that fully and safely support children's rights. So that's good. And thanks, Anita, for that. I think that was more of a comment and trying to say we all appreciate the wonderful research that you're doing, and hopefully it will be applied within Scotland and England as a whole. So Connie wants to ask a question.
Thank you very much. This was very interesting for me. I'm in ESS, my area of interest is early years education and child psychology. Now, I think when we look at the way curriculum is developed, when we look at how often we refer to the UNCRC in our teaching of practitioners, in early years settings, when you look at policy, it's referenced everywhere. And then thinking about, well, in a legal framework, it's not the same. I think that is really, really interesting. And I think it is something that my students are not really aware of massively. So if you ever think about taking that anywhere else, we would really welcome that. And I think also from a research perspective, that's really important for us. We're thinking about looking at children's voice going forward. So that's certainly something I might come back to you to get some advice. So thank you very much. That was really interesting.
Thanks, Connie. And definitely, I'm speaking for myself. Certainly, I'd be really interested to do that. And I'll not speak for Susannah's time as well.
No, likewise. It's very interesting to think of the different places in which it fits, and that's a whole different kind of sector as well.
The good thing about, thanks very much, Connie. The good thing about it is that's the reason for this kind of seminar series is to get people from different disciplines to engage. And I know, like Connie said, early years is our discipline, and it's good when we see how law, especially from the children's rights perspective, can also fit into what we're all doing. So hopefully there'll be more collaboration between Connie, Susannah, and Samuel in that space. So thanks very much, Connie. And I think there's a question from Caroline. And Caroline is asking, do you think there is a danger that human rights will be reduced in the UK, given the way things are going politically? I like that very diplomatic question, because we can see what's happening within the space. So what do you think clearly about human rights in general? Because both of you are lawyers, isn't it? So I knew it was going to go beyond children's rights to human rights itself. So I'm not surprised with that question by Caroline. So what do you think about that?
Yeah, I mean, I think we were chatting about this just this morning, Samuel, that even this morning there's even more kind of concerning developments happening, which would suggest that human rights are at risk, and the future of the Human Rights Act is something which has been put into question in recent times. So I think we absolutely need to be thinking about unincorporated treaties, the kind of wider context for human rights protection, and how we might be able to kind of future-proof our approach in law to any kind of further attacks, I guess you could say, or a removal of protections that we have kind of come to take for granted or come to accept as being there. Samuel will probably have more to say on this.
Only say I agree. I think it's probably the worst time in the world to be discussing any positives about the UK human rights protection, given the strong criticism of the Human Rights Act that we're seeing from the current government and the plans to reform it by replacing it with a Bill of Rights, which apparently, according to the white paper, will simultaneously improve human rights, but also remove some of the European scrutiny of it. So I'm not sure how those two things are going to happen. But certainly a quick look at this morning's headlines will tell you how popular things like the European Court of Human Rights are with elements of the press. I think the Mail called them meddling European judges this morning. The Express, something similar, and there were fairly negative headlines on both the Times and the Telegraph this morning, all related to the court's injunction last night to prevent the removal of asylum seekers to Rwanda. So there's a real move against human rights protection in the UK, I think, and certainly from government. And as Susannah says, hopefully by buttressing our awareness and understanding and application of unincorporated treaties, we can hopefully try and improve that and at least counter some of that rollback if it does actually happen, as the current government is trying to do. So no, a very excellent question. Unfortunately, I could keep going for hours, so I'll shut up there.
Thanks very much, Simon and Susannah. I think you're right. When we consider what's happening with the refugee and the asylum cases happening at the moment, so I think at one point we're thinking of a couple of maybe hundreds of people. The next thing became 8. I think at yesterday night, 1 hour to the time. Of course, nothing happened. So at the end, a lot of people are on different sides of it. One thing is for you to have the human rights, and another thing is for the government to agree or disagree. And we're starting to see that sometimes they don't do that. So hopefully, within your research, we believe that what you're going to do would help. And
I think just picking up on that point, Christian, if you look at how the courts are using the treaties that we're looking at, it's the civil and political rights are the ones that get the most use. The European Convention is, with some exceptions, a civil and political rights treaty. It's about the right to vote, the prevention of torture, the right to life, all of which are extremely important, but they're not the same kind of rights that we're seeing a real problem with at the moment, which are there's more economic, social, and cultural rights, and those kind of the rights to basic human flourishing that come from beyond that. So I think there's perhaps more need now than ever with the economic situation as well as the human rights situation to turn beyond just the ICCPR, the civil and political rights contained in that, and the European Convention, to look at the kind of broader rights like children's rights, like economic, social, and cultural rights.
The funny about this, two of you as the experts, we could go way and start discussing more things, but I'm tempted because I think one of the things that we're having, of course, leadership is so important. But look at the law from Brexit that's happening right now, or the Brexit that's happened, and trying to change what we had agreed initially with the Brexit arrangement. That's another conversation, isn't it? To what's happening with the asylum. So everything is still leads to what do you do when you sign an agreement or there's a treaty in place, and at the end you don't want to do it, and you start to formulate another law in order for you not to do that. So it becomes a very, very dicey thing as a government. So at the end, the government plays a very, very key part in sticking to these treaties or conventions, whether we try to push it or not. But either way, I think let's not digress and move. Let's focus on the children's rights that we came here to discuss about. But I think because a question from John: would reaching out to ethics professors have a positive influence on treaty law versus local law, and how they should be considered? So, for Samuel or Susannah, anybody that wants to start?
Yeah, Susannah, where I jumped in on the last one, do you want to kick us off, or would you?
Yeah, I mean, I think the more that people are talking about these questions and rights and how we can kind of better protect rights, the better. And I think, yeah, ethics, there's a lot of big questions there, and there's a lot of conversations to be had. I think absolutely. I think that thinking about how we can reframe law or reframe how we think about law is something that we've kind of talked about a lot recently. I know in my current PhD research, I'm trying to look at how we can incorporate kind of different ideals, different principles into law, and ideas that are maybe not necessarily always linked to law. So I'm looking at empathy and kindness, and whether or not these can be values that we start to incorporate into our understanding of law. So I think absolutely there's laws come to have a reputation as being attached to certain ideals, and values, but there's the possibility of kind of rethinking that and of looking at of why we got to the place we are and how we can improve it.
I can't add anything to that answer. I agree completely with Susannah.
It's, I had a couple ethics classes in my undergraduate studies. One of the points that was made was that the law is the lowest level of acceptable ethical behavior. So by getting it into a discussion for ethics, it might, as a public discussion, it might raise concerns to a higher level instead of just looking at the law.
I think that's a very good point, John. And thinking about that kind of lowest level of ethical behavior is exactly what human rights treaties particularly seek to be. And I think there's a really good thought kind of match up between that. You know, human rights treaties are not supposed to be the be all and end all of protection. It's supposed to be a floor below which nobody will drop, but should be a starting point for states to decide how far they want to climb above that, and actually having that kind of ethical conversation about what should and could the law do better to protect rights, as well as what just the law does at the present is a really useful conversation, and I think fits well with Susannah's idea of removing the law from the sort of pigeonhole that it tends to put itself in as well.
I was just going to, thinking back to what we were speaking about before with refugees and asylum seekers, I think thinking about the law and what it's designed to do in that context is interesting, because I've looked recently at, can we kind of reframe how we think about it? Can we reframe how we think about refugee protection? Because ultimately it could be thought of as a sort of legally obligated compassion, that we're seeing people who are in need, who require protection, and we're seeking to alleviate them from a difficult situation of a dangerous situation. So I think yeah, there is moves to think about law and how it relates to different kind of emotions, and how we can rethink what law is actually there to do. So yeah, no, I think that's a really good suggestion, John.
Okay, thanks very much, Susannah and Samuel, for that, and thanks, John, for that question as well. I think Caroline is also adding something here as well. She's saying it almost feels like children's rights are safer than general human rights. So we might see less criticism of the UNCRC than the CHR, for example.
Yeah, again, a very good point. If you look at the narrative that's being spun, the ECHR is the main target at the moment. It helpfully has the word European in the title. So that means that there's certain elements of parliamentary parties who seize on that and maybe suggest it's more related to the European Union than it is. They are entirely separate. But I've noticed, again, recently, politicians confusing and conflating the two. I think there's also, it takes us on the kind of realm of treaty compliance. The ECHR is often a target because it's got one of the most effective compliance mechanisms of any human rights treaty. UK's compliance is actually very high with ECHR. But if you look at the overall rate of compliance with some of the UN human rights treaties, it's much lower. So there's much less threat to the government. But I think you're right, things like UNCRC are much less likely to be attacked at the moment than the ECHR. I mean, in terms of low levels of compliance, I'm talking about 12% is the compliance rate with the ICCPR's treaty body decisions. So in other words, 88% of their judgments are not complied with, which is a concerningly low figure. Is probably a polite way of putting that. But I think you're absolutely right, Carolyn.
Yeah, I guess again, in terms of kind of immigration issues, it's sometimes how we see the other. So or people are generally happy to have rights themselves, or for children to have rights, but it's the other, and how we can understand that human rights really are attached to people because they're human, and that means that everybody should be able to have them recognized. So I think it brings up kind of wider questions about how we frame rights, how we reflect on it, and how we kind of, I guess all of it comes again back to education perhaps, and improving that certainly is a good starting point.
It fits quite well, that point, Susannah, with the narrative that we're seeing around the Bill of Rights is that the Dominic Raab's paper very much says we're going to reframe rights, so it's rights and the corollary duties that go with them. And there's a really strong push from the government at the moment that we're going to kind of make sure there's a greater balance between rights and duties, which seems to elide the fact that by virtue of humanity, we all have human rights. And I think that follows on from your point, Susannah.
Thank you very much, Sam and Susannah. Something that you said, Samuel, it's like 88% non-compliance, and that's really sad. So how can we improve it then? I think Susannah was saying education. Do you think that is the only way we can improve the compliance?
I think education is an enormously important way to go about doing that. Publicizing in individual states the results of these decisions is an important way of doing it. There's I think probably a bigger question, and I've just attended a conference about this actually, so I can vaguely remember facts. That's why I can remember the 88% non-compliance rate at the moment. But there's a big move to look at how treaty compliance mechanisms are drafted. The example I gave was the International Covenant on Civil and Political Rights. Most of the UN treaties have similar systems. So what you've got is a treaty and then an independent body that oversees that. And they are kind of the guardian of the treaty and they make decisions about compliance. The problem is you can't always go directly to them. So there's what's called a right of individual petition that allows me as a person in a state that's a state party to the treaty to go to the treaty body and say, my rights have been breached. What are you going to do about it? The problem is that that system is opt-in. So it's the Human Rights Committee is the treaty body for the ICCPR. The UK is not a signatory to the optional protocol that allows me to go. So in other words, I can't in the UK go to the Human Rights Committee and say my rights have been breached because the UK just doesn't allow me to do that. There is no mechanism for me to do that. So it's twofold. I think we need to publicize and to educate more broadly about the role of human rights and about the content of human rights, but probably have bigger discussions about the way treaties are designed. Are they designed cynically to allow states to sign up to treaties and say we're joining the club of nations that approve these rights? Or are we creating systems that actually protect human rights, that don't allow that wiggle room for states? For anybody who's interested in that kind of area, there's a brilliant article called Do Human Rights Treaties Make a Difference by Una Hathaway. And she talks about that kind of weird cost-benefit analysis that states do. They'll sign up to these treaties and then fairly cynically breach them, but they get the benefit of being the treaty party without all of the duty. And there's some quite worrying statistics that she shows about how states that signed up to the UN Convention Against Torture actually had higher rates of torture than those that didn't, because they could point to the treaty membership when anybody said, are you behaving yourselves? And they would say, oh, we're members of the UNCAT. So of course we are. And it led to these kind of perverse outcomes that shouldn't be possible, but are. Susannah might have some thoughts on that as well.
No, I think you've said it very, very well, Samuel.
Thank you very much, Samuel and Susannah. I think you're right, clearly. I think education is important, and hopefully the CPDs that you two of you wanted to develop for the lawyers going forward might be one of those things that they should come and speak and hear from you. And definitely we'll be calling both of you by the time you have your findings from your qualitative study as well to come and share with us and tell us what you have been able to get from your study. So we're looking forward to hearing much more about your study going forward as well. I know we have just a few minutes to go, but any questions you have, any comments, any pressing thing you want to say in the next few minutes before we close?
I think we've got another question from John, Christian, asking if there's a legal ethical authority that reviews legal decisions, and asking also how often is the topic brought up in law school legal reviews. The answer to the first question, I think, is no. Legal decisions are appealable only to their final court. So in the UK, except for certain things, it's the Supreme Court. And once the Supreme Court has had its say, that's that. The Supreme Court are more willing to look at the bigger picture than just the law. They have quite a lot of power to bring extra factors into their decision making. But that's the kind of end goal. And kind of questions about this topic in terms of human rights being brought up in school law reviews. Human rights are discussed quite broadly. The ethical legal side of things, I think, less so. And you only have to look at the way in which I think a lot of places teach things like legal philosophy to see it as maybe not a central focus. I think we've got we're lucky we teach first years legal philosophy and hopefully have them thinking about these kind of questions from the outset and looking at law as part of a bigger system. But certainly when I was at law school, we touched on philosophy of law very briefly and very quickly. And it was seen as a tick box for the Law Society to make sure they were happy that we'd covered everything that we needed to. I'm aware that Susannah may have had a very different experience to me.
I think mine was very similar. It's not, I think LLB programs often prepare you to go and be a lawyer. So you have to get through the certain programs, and the kind of ethics side of things isn't kind of explored in as much detail as it probably could be.
Okay, thanks very much, John, for that. And maybe we need to tell the Law Society, isn't it, that we need to know more about ethics as lawyers rather than just looking at law or focusing much more on law. There needs to be a balance, and maybe we will have better leaders going forward, and maybe the government will be able to do things clearly. Well, it's great to have everyone here today. Thank you everyone for this presentation. I think that's what Anita is saying. Thank you for this informative presentation. Thanks everyone for attending, and thank you so much, Susannah and Samuel, for the very informative, apt talk today. I think it came at the right time, especially with what we're seeing in the world today about treaties and the law itself. I found it very informative, and every other person here as well, from the feedback, they also enjoyed it. And John is saying thank you. I enjoyed the presentation very much. So I think it was a good one, and we are expecting to see you soon. To tell us much more as you go along with your work and your study, and we know that it's going to inform the law practice going forward, and we're proud to have you in our school, and I'm very sure Caroline would also say the same as well. So next 2 weeks we are going to have someone special as well that will be looking at trust. So watch the spaces, and a standout person, and the person is from Aberdeen. That's Dr. Kingsley O'Malley, and you'll be looking at trust in detail. So we're going to be presenting. I think it relates, isn't it? Now from law ethics, we're moving to trust. So I think there's a story around, so you'll be able to see that. But either way, thank you so much everyone for coming. I don't want to let you stay. I think it's sunny outside, and I'm sure it remains sunny for a good period of time. So go and enjoy some of the sunshine, and see you in the next 2 weeks. And thanks everyone for attending, and thanks to our excellent speakers. So take care and have a nice day.
Thanks very much, Christian. Thank you for having us as well.
Take care.
Bye-bye, everyone. Cheers. Bye.